Good afternoon, Phil. As you know, I'm Reena Hajat Carroll from Confluence Rising. I'm so excited to be able to talk to you today. Can you share a little bit about who you are? If we can start with your name and where you're zooming in from.
Name's Phil Hirschkop. I was raised in Brooklyn as a child, and then most of my remaining teen years and young years in central New Jersey. I've lived in the Washington, D.C., Northern Virginia area for over 60 years.
Thank you for being here, and thank you to Zoom and technology so that we can have this conversation across the country. So thrilled to get to learn more about your story and your career and your critical work with the Loving versus Virginia Supreme Court case of 1967. Can you share a little bit about what your involvement with that case was?
I was the lead counsel for the Lovings. I had just graduated law school a month before in 1964, and I was deeply involved in civil rights. I spent a good part of that 64 summer in Mississippi doing voter registration work and representing demonstrators. It's the summer the three kids were killed down there in Philadelphia, Mississippi. And I was visiting with my con law professor at Georgetown Law School, and a young man came in who had the Loving case, but he'd filed a one-page petition and he just had no idea what else to do with it. So he came to consult our constitutional professor, who was well known, and he referred him to me since I had gotten deeply involved in civil rights. Within a couple months, he asked me to join his firm, and I did. And I took over managing the Loving versus Virginia case, argued it in the federal court, in the district court, in the Supreme Court of Virginia, and then made the lead argument in the U.S. Supreme Court.
How long did the entire process take?
Well, he filed the petition, Cohen filed the petition, original petition, in October 1963, and the Supreme Court rendered their opinion in June 1967, June or July 67.
And can you talk about what motivated you to get involved with civil rights prior to the Loving case?
Well, it's a lifetime of experiences. There's no single factor that motivates, but there are some turning points. Where I was raised in New Jersey, there were a lot of migratory laborers, and there was no control in those days for those people. They'd come up in the back of a truck, and they'd pick potatoes, and they were putting cleaned out chicken coops with no running water in their bathrooms or bathrooms. And my pop, who had been a waiter in New York in downtown delicatessens of Manhattan, had retired, got his three sons away from a tough area we lived in Brooklyn. And he wanted to settle there. So he had a little catering business and he opened a little store. And I dealt with a lot of these migratory laborers and saw what happened to them. Uh, and that passed because I graduated high school. I went in the Army. I was a Green Beret, the original Green Beret unit. And when I got out, I went to Columbia and I didn't know what I wanted to do. I started as a music major. I got an engineering degree. I got a liberal arts degree. Somehow I ended up in law school. It was a pure accident.
Mhm.
And I got to know my con law professor. And one night I was going to class, went to night school, and he invited me to a meeting at the Hotel Washington in downtown District Columbia. And that was the day that President Kennedy had a meeting of lawyers at the White House to see what could do to straighten out what was happening in civil rights through the legal system, white and black lawyers. And included were black lawyers, African American lawyers from Danville, Virginia, where just a couple months before they had one of the worst mass beatings in the history of the South. And so when I went to that meeting, I met a well-known civil rights lawyer from Detroit, and he invited me to go to Danville that weekend, just out of a blue sky, and I did. And I met Bill Kunstler, a famous civil rights lawyer, became my mentor, and saw what was happening and got in a black church, saw the videotapes of the horrible beatings of the people. The chief minister's wife, who was like an eighth month pregnant, She was very large at that point, described it like trash being washed down a street after heavy rain. These cops had put them in a narrow alley and put big fire hoses
Mm.
trained on them. And after seeing that, I came home. I was employed at the U.S. Patent Office. I was going to be a patent lawyer because I had an engineering degree. I went back. I resigned from the patent office. I had a job on Capitol Hill for a while. And that following summer, I graduated law school. Prior to graduating, as a result of my work in Danville, I helped organize the Law Student Civil Rights Research Council. We put hundreds of students in the South, raised money. Practically all the law clerks in civil rights offices was supplied by our council. The summer of 64, when I was in Mississippi, a good part of summer, I was supervising 100 students all over the South. Uh, those things all taken together, I ended up being a civil rights lawyer.
Mm. Well, I am so glad you made your way to law school by way of engineering and all the other ventures. So going back to the Loving case, in those 4 years that you were working on it, did you feel at any point that it was not going to be successful? And if you did feel like it wasn't going to go in your favor, why did you feel like that?
Well, it's a complicated question, more so than you think. I got involved in the case a year after it was initiated. Cohen, the young man who had filed a one-page petition, Mrs. Loving, to start the whole thing in 1963. And I don't want to string this out, but it's important to understand the years of 1963 and 1964. They're crucial in civil rights. And 63, of course, you had the March on Washington. But you also had Medgar Evers' assassination, you had four girls bombed in a church in Birmingham. You had the introduction of the Civil Rights Act with Title VII. Everyone knows about Title VII, but also Title IV for equal accommodations. And it was culminated by the assassination of John F. Kennedy. Then in 64, you had the passage of the Civil Rights Act. You had the three boys who were killed in Philadelphia, Mississippi, and a host of other things. Also in 63, you had the Danville mass beatings in Danville, Virginia, which was the second capital of the Confederacy. Um, those things are intertwined with the Loving case. Mrs. Loving was convicted in 1959 and her husband, and told they had to leave Virginia and they couldn't come back for 25 years together. And all they wanted to do was be with their family. They weren't civil rights heroes. They didn't want to be glamorized. They didn't want to get involved in a lawsuit. And so when all the advertising came out in 1963 about the March on Washington, the famous mountain speech, uh, Mrs. Loving tried going back to Virginia and was advised she should write Attorney General Robert Kennedy, and she did. He advised her to write the ACLU, which she did. The ACLU sent it to their DC office. There was no Virginia ACLU back then. And they decided to contest the sentencing. The sentencing was clearly illegal. It's called banishment, and the law has clearly said repeatedly across the board that it's not a recognized under due process sentence. And so the ACLU filed this petition through Cohen here, but the young man Cohen, he had no background in criminal law and appellate law and constitutional law and civil rights law. He had a local family practice with two other people in Alexandria, Virginia. So he didn't know what to do. He went to see his con law professor, and he did that. After a year, nothing had happened. He filed a petition in October of 63. By June of 64, the President Johnson had forced the Congress to pass the Civil Rights Act. And just like 2 or 3 days after it was passed, the Civil Rights Act, she wrote to Cohen. She says, "Do you remember us? We're the Lovings. We've about given up hope." And so he went to see his con law professor, and I happened to be there, and we were introduced, as I said before. And I got involved then, I saw that he had made a big mistake in what he filed. Had they granted a new sentence, the likely that Loving case would never reach the U.S. Supreme Court. It had been blocked for some technical reasons if that happened. Uh, so I told him in that first meeting we needed a federal independent action. In those days, you could seek a three-judge court for that kind of action, federal court. And so I drafted one the night I met him on a plane. I was flying back to Mississippi on an old fool's cap, the big yellow pads. And I sent it to him. Within a couple of weeks, he offered me a job. I was going to go back to New York, where my family's all from, practice law. And I settled in Virginia and took over the Loving case. In those days, we weren't sure where it was going to go. The Virginia Supreme Court was no different than Mississippi or Alabama Supreme Court. They were very racist.
Mm.
Uh, and so we did file the three-judge court action. The state then vehemently opposed that action. We ended up in an argument in January 1965 uh, before the three-judge court, and they agreed with the state. This was a state question, but they said it raised serious federal questions also. So we appealed to the state court, not much hope of any relief there. And they, of course, turned us down. We got a special ruling that we could go on an expedited appeal. This opinion they wrote affirmed an opinion from the trial court where the trial judge had said that God created the races on separate continents, and but for our interference, that's how it should remain. He was also a bit of a racist. Uh, and we then lost in the state Supreme Court. Interestingly, they did revoke the sentence and were remanding it for new sentencing. Given that I thought after consulting with other lawyers, I'd never argued in the U.S. Supreme Court. I was only 2 years out of law school at that point. Well,
Mm.
actually, at that point, I was a little over a year out of law school. Uh, but after consulting, I thought there's little chance we will get review. The Supreme Court only accepts very few cases for review. They're all what we call permissive appeals. It's not an automatic right to appeal to the Supreme Court. Well, it's a right to appeal, but they don't have to accept it. And the Supreme Court had been avoiding these type of cases. After Brown, the country was up in arms. We had the National Guard escorting kids. We had Governor Forbes and the steps of the high school blocking kids in Arkansas, and the governor in Alabama blocking these kids. And before that, we'd seen buses lit on fire with teenagers in them during the Freedom Rides. Uh, so it was a very difficult period. And during that period, in light of all the hubbub over, least I can say hubbub, was a lot worse than that, over the Brown v. Board case, there was a case came up to Supreme Court, name versus name. It was from Virginia. It was a Chinese male and a Caucasian female. And the Supreme Court refused to grant cert in that case. And we found some letters from the Supreme Court in their files where they didn't want to take on the at that point uh, the problems it might cause. There was a famous study done by Swedish economist Gunnar Myrdal about civil rights in the South, and he had a large section about the thing feared most in the South was intermarriage, especially a black man with a white woman, which is the opposite of the Loving situation.
Mhm.
It's a white man with a black woman. But until they granted review in the U.S. Supreme Court, I didn't think there was much chance we'd win the constitutional questions. We certainly would get the sentence redone, and that's why I said a big mistake was made originally. The statute required up to 5 years in prison. They couldn't be put in a local jail. The local judge, when he said go away for 25 years and don't come back together, had sentenced them to a year in the local jail. So if they resentence it, there's a good chance they'd both end up in the penitentiary for 5 years. But since I had brought that federal three-judge suit, and we had that pending saying, if you don't get relief in the state, come back here, I think that influenced the Supreme Court. And it was a case that had reached its time, and the Supreme Court granted review. When a Supreme Court granted review, that was the first time I felt really good. There's an excellent likelihood we're going to prevail.
Wow. And so thinking about many years ago, 70 years ago, you're a young attorney. You are working on what is now one of the most important legacy cases in our social justice world. What did you feel? Do you remember what you felt when you heard how the
Well,
case?
we heard we felt good, but I had no question by then we were going to get great relief. The question is the extent of the relief. Uh, we went up on four issues, Supreme Court. One, of course, equal protection. The second is substantive due process. It's a strange thing that probably doesn't exist anymore because of Antonin Scalia, but that is where something is so outrageous or difficult and contrary to accepted norms, the Constitution will protect it. And so that's where the Roe v. Wade case is from. There's nothing in the Constitution about you can't get an abortion or you can get an abortion or a woman's right to choose. And the right of privacy was recognized in that way. And loving, when it was decided, was recognized that way. Just there are certain rights so fundamental to being born in a democratic society that the Constitution doesn't uh, create them, it protects them. So for the First Amendment, Second Amendment, Third Amendment, right to free speech, freedom of religion, right to bear arms, right against unreasonable search and seizure, the whole thing in the Bill of Rights, they're all rights created by the Constitution. But there are no enumerated rights when it comes to miscegenation. But the Supreme Court, hell, that was a very major thing because when you get to same-sex um, marriages, and loving's the main thing. It's the substantive due process that applies. So we had equal protection substantive process, and then it's procedural due process. All these statutes were based on what is presently, it's going to surprise you a little, the racist definition of races that we still apply today. You take President Obama, everyone tell you he's African American. Why isn't he Caucasian? Because the laws were, through all the racist laws, that if you had one drop or a trace of Negro blood, then you're African American. Well, why if you have a trace of white blood, you're Caucasian? Because the whole purpose of those laws was preserve the purity and the sanctity of the white race. And it had that language in it, preserving the purity of the white race. And we still apply that standard. So going back to the due process argument in Loving, there's no way you can measure a trace of Negro blood or one drop of Negro blood, or so it procedurally couldn't be enforced with reason. So there was a clear violation of due process. And the fourth point, of course, was the improper sentencing, which we didn't want to broach. I was afraid, we put it in our brief, but I was afraid if Supreme Court granted that, they'd remand it just for new sentencing and maybe strike down one statute for procedural due processes. Fortunately, got by that. I believe from letters we've seen internal to the Supreme Court that the Chief Justice who wrote the opinion was very concerned to get a unanimous opinion to be less challengeable in the future, particularly if he picked up the two dissident votes we were afraid of. On the Supreme Court then was Justice John Harlan, who was known as the Great Conservative. Unlike the conservatives today, he was decent and reasonable. The conservatives on the Supreme Court. He was decent and reasonable. He didn't take graft. He didn't take funny trips from people. And he enunciated the laws he sought. But looking through past cases of his, we felt we could win before him on a procedural due process argument. The other one was Whizzer White, who was a Kennedy appointment. President Kennedy had a terrible record for judicial appointments. He appointed two judges in Mississippi one of whom had been Senator Eastland's roommate in law school and used the N-word regularly on the bench. Uh, but that Kennedy was very political with that's very Boston type thing, using judges as political tools. Um, Not to say anything about the federal judges; they have a real history of great judges, but
Mm.
Massachusetts. At any rate, so we had those four issues going into the Supreme Court. We had a bit of a falling out among the lawyers for the Lovings about which issue we should pursue.
Mhm.
I, being deeply involved with civil rights by that point, although still only 2 years out of law school, insisted we make equal protection and substantive due process our calling card, our main. Now, I made that as the lead argument. We then both Cohen argued the procedural due process. We ignored bringing up, I haven't forgot your question. We ignored bringing up the sentencing. But during that oral argument, I think there may have been one question for me. It was a easy shot. I don't remember what it was. It was a simple question. I think Wizard White or Potter Stewart asked me. But then Cohen got up and he got a couple of questions, I think also from Potter Stewart. When the assistant attorney general and there was an argument also by one of the amicus from the Japanese American League, because remember I told you the
Mhm.
name case, although it was Chinese, but then classified as Orientals.
Right.
And so Mr. Moritani made an excellent argument, but pertaining just to that narrow group. Then when the Assistant Attorney General, Mr. McElwain, argued, he and the Chief Judge went at it for half hour. The total argument he had lasted more than all the rest of us put together. And his argument was, well, this is a slippery slope. It's going to cause all sorts of uprisings or problems and et cetera, et cetera. The Chief Justice said, ain't that the same shop-worn argument you gave us in Brown versus Board of Education? He tried quoting this expert who was just a racist who wrote a book that, black people aren't as qualified and a bunch of other crap. Uh, and the Chief Justice put him down. After that argument, it was hard to envision we could lose. There was still a chance we might win only on procedural due process.
Mm.
So they might strike down one or two statutes just to Virginia without a broad ruling that says this applies to all interracial marriages across the United States. So when the opinion came down, I was absolutely sure, as much as you can be, and nothing's guaranteed in the law, that we would win, but not as big as we did. It was a complete ratification of our argument on equal protection and substantive due process. And what happened, of course, is many years later in Oberfeld on same-sex marriage, loving is what they quoted, and they quoted particularly the language that goes to substantive due process.
Wow, this is so incredible. Thank you for just the historical and legal context.
Mhm.
And I know we could spend all day talking because this is fascinating for us, and we are just so, so grateful.
I get hundreds and hundreds of requests a year to speak. I turn down practically all of them, except for years I made an exception at schools.
Mhm.
And schools have these debates, they have these paper writing, and a lot of kids in junior high school, particularly, call me up and say, I've selected the loving case. And my teacher said, would you give me an interview? So I've talked to countless young people about this was the law and this was the history of the law. Here was where it came from. Law goes back to the 1600s and starts in England. And they ask a number of questions, some very interesting questions. They really think it out. Uh, the relationship of people treating each other in racial problems with how we treat animals, the racist, because I was also counsel to PETA for 40 years,
Mm.
and I taught animal rights law for a little while at George Washington Law School. Um, but the analogy of brutally treating people and brutally treating animals can be very close. But to answer
Mhm.
your question, many times I've been asked it, and the kids understand. It's a question. if I'm less into the legal stuff, then I answer your prior questions, and explain it in terms that they understand. They do appreciate it. No one can appreciate the horror of what when you're being oppressed like that without being in their shoes.
So I had shared with you, I have two biracial children, and I was sharing with them that I was meeting with you today and talking to them about the case, and they are 10 and 16 and couldn't even imagine a world in which their parents could not get married, right? And the shock, the the disappointment, all of the pieces. And it is something that we do here at Confluence Rising with our young people. We are always talking about justice, about equity, about how important it is to stay in the fight, to continue to work, to make sure our values are seen in this generation and generations to come. And so, with that, I'd love to pivot and ask you our final question, which is around something big, broad, no right or wrong answer, just whatever's on your heart. Would love to know. I know you just celebrated a birthday. So at 90 years old, what have you learned about life?
I've learned to accept what I see and not what I hear. In civil rights, the most important thing, and I taught constitutional litigation at Georgetown for a number of years, Georgetown Law School. And the most important thing in a civil rights lawsuit is why. Soon after Loving, I took a case to the Supreme Court that knocked out the pregnant teacher prescriptions across the United States. In those days, almost every school board in the United States had that a teacher couldn't teach past the fourth or fifth month of pregnancy. And when I asked why in a deposition, the school board member who proposed it says, well, we don't want him thinking she has a watermelon in her belly. Well, watermelon in your belly. I mean, this was an 11th grade advanced English course teacher in high school. When I got to the Supreme Court and I raised that, Chief Justice looked down at me and said, move on, Mr. Hirschkop. In the Loving case, uh, we had a lawyer from New York help us write the brief. He was terrific. The final brief, not all the briefs I'd written up to them myself. And we analogized what was happening in the case to the history of races in the United States. So we went to how the Irish were treated coming in Boston, and the Jews and the Italians in New York, and the yellow peril in California. And again, I was told to move on. You got to remember the Chief Justice of the United States previously had been Attorney General of California and had signed the commitment papers for the Nisai there. Um, so I've learned that everyone, you go to a lawyer and say, hey, you any good? He's going to say, he's great. I learned to ask him, how many cases have you tried like this? And can you appoint me one night and go check out your filings? You get into a lawsuit and people want to tell you what they think you want to hear. Uh, and you've got to learn, listen, but check it out. You see in our politicians, you vote for somebody and then they go to do
Right,
it. They may not get what you bargained
right.
for. We see what's happening in the destruction of our democracy now. Uh, but that's it. I learned not turning 90, and it's a big part of why I was in civil rights. I'd come home as a young boy. I was the youngest of three sons. And sometimes my mom would have this little urchin sitting there. Kid didn't smell very good, but I hadn't had a bath for a long time, eating with us. If she see a kid on the street and he looked hungry, she'd bring him home to dinner. She was totally kind, my mother. I adore my mom. She just believed in humankind. She never raised a voice. I never heard it. My father, who I also adored, the only picture I have on my desk right now is a picture of me and my father the day I argued in the Supreme Court of the United States on Loving versus Virginia. And it lets me, when people come to me and they want advice, I don't know the answers. We had an expression in the Army, no mommy, no daddy, no first sergeant. Uh, but you can give a more educated guess than maybe the client can. And I'll look at my pop in the picture and I'll say, hey, Pop, what do I do now? I'm kind of stuck. So I've learned to listen. I've learned to think it out. I've learned to not let my ego get in the way.
Mm.
And I've learned the kindness from my mother and the integrity from my father to seek justice. Final words my father said to me when just before he died, he was on a gurney in a hospital in Florida, and they had tied him down because he'd come out and he was thrashing about. And I walked in, I just flown down from Virginia, had emergency surgery, and I rushed down there. And he looked up at me, he says, "It ain't right, Philly." Uh, and that's been the story of my life since then. And those words, I learned right and wrong.
Mm.
Unfortunately, my father didn't see a gray area, and that was a shortcoming.
Mm. Wow. Wow. Phil, thank you. As I said, I would love to extend this conversation for 8 more hours. You are just a wealth of information, and it is so interesting. It has been our honor, our privilege to even just be able to hear this small snippet of your life, your career, your history. Thank you again. Just thank you so much for what you've done, all of the diversity of cases that you tried, the success that you've had. We are living better lives because of it. And so just thank you. Thank you so, so much for this time together, but thank you for just a lifetime of incredible work.
And thank you, because I'm familiar with your organization and wonderful work it does. So thank you for that, and thank you for your kindness today.